Morena, gentlemen, welcome to another fantastic day of online learning. So today's class kicks off by reviewing the activity set in last lesson, which is task 9 on page 15 of the workbook. So I'd suggest that you pause the screen, just have a read through of the model answer relating to the question of explain why you think the Disputes Tribunal allows interpreters and representatives in certain cases, but not lawyers at hearings. So a key part of our answer here, guys, was to be talking about fairness and effective communication. Because representatives are only allowed where the applicants are under 18 or have a disability that impedes them from making their case, which makes a representative necessary for fairness and effective communication. So the representative for these types of applicants will help the referee get a full account of the issue, all the facts relating to the dispute, which will help the referee to make the most appropriate and fair order. So without these representatives, hearings would be unfair for applicants that are under 18 or have a disability that impedes them from making their own case. Interpreters are also important to help ensure that all parties are able to understand and engage to participate in the hearing, which is critical in our multicultural and multilingual society, and to also include our deaf community. Without interpreters, a hearing could be unjust, it could be unfair, it could be ineffective. Lawyers are not allowed at the disputes tribunal because lawyers are highly trained at making arguments. They are also expensive to employ, and they would increase the formality of hearings, which goes against some of these goals of the disputes tribunal, which is to ensure justice in an informal, quick, and inexpensive context. Also, if one party had a lawyer, they had that expert and highly trained professional at making arguments, it might unfairly disadvantage the other party that doesn't have a lawyer. As promised in prior lessons, we are starting the final examinable topic of Unit 6, which is the Fair Trading Act. And the Fair Trading Act, similar to our Consumer Guarantees Act, is a piece of legislation. It is law. It is a statute that is created by the New Zealand Parliament that outlines the responsibilities of businesses to act in a fair manner when supplying their products. And throughout this topic, we're going to be looking at what is fair and what is unfair conduct by businesses. The FTA, the Fair Trading Act, applies to any business, large and small, right from your Air New Zealands of the world through to our favourite local ice cream truck. The FTA provides rules, it regulates all advertising, and that's quite topical seeing we've spent a bit of time in this course on marketing and advertising, as well as those dealings, those interactions, those face-to-face conversations, as well as the phone calls between the business and consumers. The purpose of the FTA is similar to the CGA, the Consumer Guarantees Act, and that is to contribute to a trading environment in which consumers are protected, businesses are able to compete with each other in an effective manner, and also that consumers and businesses have the confidence to engage in transactions, to engage in buying and selling goods and services. To help achieve this purpose, the FTA prohibits certain unfair conduct and practices in relation to trade, so how they go about supplying their goods and services. Of course, we're going to look at a few examples of what unfair conduct and practices are. The FTA, on the other hand, serves to promote fair conduct and practices to give businesses an incentive to act in a fair manner to consumers and their competitors. The FTA also requires the disclosure or the making known or informing consumers about facts relating to the goods and services that are supplied. And also, the FDA is there to promote safety in respect of products, making sure they are non-hazardous and safe for consumption. So if a consumer is buying a product, they can presume that the FDA applies to the supplier and the supplier of the goods and services that are being bought. In some situations where a customer is the consumer, where a business is the customer, in those cases where it's a business to business transaction, it is actually possible for these businesses to agree in writing to exclude. To exclude means to not apply some of the FDA responsibilities that are otherwise on businesses. However, this exclusion of FDA obligations must be fair and reasonable in the circumstances. So in summary, if you're out and you're buying something as a consumer, you can be safe to think that the FDA is going to be applying to that transaction. Now let's have a closer look at some unfair conduct, and that can be said to be misleading or deceptive conduct. So businesses under the FDA must not engage in misleading or deceptive conduct, or conduct that is likely to mislead or deceive. So deceive or deceptive, we're talking about tricking consumers, giving consumers a false or confusing understanding of what is actually the case. So it doesn't matter if a business did not intend to mislead the consumer. It's not an excuse to say, hey, that was an accident, that we confused all our consumers about the manufacturing process that we use. It just needs to be the case that consumers are misled, or it is reasonable to think that a reasonable consumer would be misled by the conduct of the business. In some situations, remaining silent or failing to mention relevant information about the product could be considered misleading or deceptive. So by not telling consumers everything that's relevant about the product or the sales process, the business might have actually misled our consumers. Kind of like that saying about a half truth or lying by omission. So by not including certain facts, consumers might be tricked or might get the wrong impression about the situation. And so therefore the business not even telling a lie, but failing to tell what is relevant or all that is relevant to the product could still mislead or deceive or trick our consumers. An example of some misleading conduct by a business is one from a few years back where a business was selling Nurofen. Now, Nurofen is a very common pain relief medicine that is easy to get because it applies to really general pain that people experience, and it works against inflammation, and can be taken for a whole range of different symptoms, different ailments, different pains. But this business decided to be a little bit tricky, and it decided to market Nurofen to different market segments relating to different pain that people experience. And it marketed Nurofen differently to each of those different pain type market segments. So it created a Nurofen product that was specifically targeted for migraine relief. They marketed Nurofen so that it was specifically targeted for back pain. They marketed Nurofen so it specifically targeted period pain. So consumers got the impression that they were buying a version of Nurofen that was specific to these types of pain. and they charge consumers more for these specific pain-addressing Nurofen products than just the normal Nurofen. This was deceptive conduct, of course, because all of the Nurofens worked identically. There was nothing different from the back relief Nurofen product to the more normal general Nurofen product. So consumers were misled into thinking that they were purchasing some pain medicine that was going to specifically help with their specific issue. But in fact, they were just buying the normal bog standard general Nurofen product that applies all in the same way to relieve general pain. So the business had been misleading in how it marketed the Nurofen product. Today's activity, guys, is to complete task 10 on page 18 of the workbook. And this is going to be asking you to consider whether lying by omission or failing to disclose relevant information, a half-truth, whether in fact that is misleading or deceptive conduct. Any questions or issues, please email me or your classroom teacher. All the best with today's learnings. Kia kaha.